Hi, I'm Greg Dell with Dell Disability Lawyers, joined by attorney Cesar Gavidia, and today we're going to talk about one of Cesar's resolved cases against Prudential. And Cesar, we love to talk about these cases because it shows a great victory for a claimant, something that we're really happy about achieving. Also gives us the opportunity to help claimants who have been denied to learn what it takes to win an appeal, and then provide tips for people who hopefully can protect their benefits if they're on claim by learning how Prudential chose to deny this particular claim. So let's get into the background of your claim.
Yeah, so Greg, our client was a private client advisor or wealth advisor, finance advisor for, and worked for JP Morgan Chase. He was diagnosed with a very severe neck and face cancer that also went into his mouth, had to undergo a number of very difficult and painful surgeries and recovery, radiation therapy, chemotherapy, to really fight and beat back the cancer. He sought disability benefits under the JP Morgan Chase long-term disability plan, and as we've seen in many cases, he was paid really without any question or challenge for the first 2 years. And then after 2 years, Prudential started a review of his medical records, of his occupational duties, of his qualifications, and basically ability to work in a gainful occupation, despite him already being paid and receiving Social Security disability benefits.
Why? What was significant about the 2-year mark? Why were they doing that then?
So under this group plan, group disability policy that JP Morgan Chase has and provides to its employees, it essentially provides disability insurance for the first 24 months of your disability if you're disabled from your own occupation. So in this case, his occupation is a private client advisor. After 2 years, that definition of disability changes to what we call the any gainful occupation standard, which basically at that point it's a question of whether you're able to perform any gainful occupation that you're qualified based on your education, training, experience, and in some cases how much you even are earning or did earn prior to your disability.
And I think that Prudential has an income component, a lot of them, where you have to be able to earn at least 60% of what you were earning.
Right. That's why when they do these reviews, it's really important that that's something that's also looked at, because it's not fair to just look at, let's say, maybe some training, some past education they've received to say he qualifies for these specific occupations when those may fall well below the income component. Yeah.
Okay, so what happened in your claim? They obviously paid him for 2 years.
So they paid him for 2 years, and then, as is standard basically in all these claims, they started a medical review and an occupational review at around, the 1.5 year mark. And it took a few months. The medical doctor that Prudential had essentially did a review, came to a conclusion that the review he'd done of the records didn't support that he would be restricted or limited from performing a gainful occupation. Reached out to our client's physician, had a conversation with them where the physician, actually the oncologist, reviewed had a conversation with them, whether they reviewed the records, their own records or not, I'm not sure, but they essentially said that they recovered from the chemotherapy well, they recovered from the surgeries well enough that although he has some limitations, it wouldn't be, he wouldn't have limitations from speech or from even essentially eating, which in fact, he did have limitations from. That's exactly the opposite of what he should have been saying, because our client, because of the surgeries he'd undergone, he could barely speak. His speech was extremely slow and barely even able to understand. He had to have parts of his tongue removed. He couldn't even open his mouth much to even be able to eat. So he had to take most of his nutrition in through a feeding tube. So if you can imagine, now they're saying you could go back to working a gainful occupation, even your own occupation, as a client advisor, which, essentially communication is the primary activity there.
Of course. What job did they suggest he could do?
Well, there were a number of jobs, basically, all of them requiring, some interaction with the public, some interaction with the client, which is what he was doing before. essentially saying, look, not only do we think you can do a gainful occupation, we think you could go back and do your own occupation, which requires a lot of interaction and communication with clients, which he wasn't able to do. So when we took on this appeal, we thought it was very important because the number one thing was to establish the foundation, go back and have to reestablish this foundation with this doctor. They went back, did a review of their records. We had them complete a very specific customized questionnaire that was addressing specifically the restrictions, limitations, and how they would affect his functionality in performing his own occupation in any occupation. This was all done as well as addressing really the flawed review and analysis of this medical reviewer in Prudential. And we were successful. The claim got overturned and it got approved.
When you said you completed an attending physician statement, meaning you drafted something that went back to this oncologist to get him to clarify his position?
So it really what it is a very specific questionnaire. Because if you look at you mentioned attending physician statements, I don't really call these attending physician statements because that's very similar to what the insurance companies call them. This is more of a functionality questionnaire. It could be done by this person's primary attending physician. It could be done by other physicians that are also attending to him or seeing them or treating them.
And who did you send it to in this case?
So in this case, it was important to go back to this oncologist. Because I think that they made a critical mistake even in understanding what our clients' limitations and restrictions really should be. Because it was just exactly opposite of what his symptoms were and his ongoing problems were.
And then once you had a conference and spoke with the oncologist and explained this custom questionnaire that you had done, and even further explained that this wasn't about just activities of daily living, this was about committing to a job 8 hours a day.
Right.
And so what was the feedback from the oncologist at that point?
So at that point, he was able to adequately and accurately describe what the limitations were. I mean, went in and described in detail how he could barely open his mouth, how he required what we call a peg tube to even take in most of his food. So we would have to be there, if he were to be in a work environment. Let's say even sitting around having lunch with a client, which is a very important component, being able to network and go out and not only maintain the business, the clients that he has, but have to go out and generate new business. And one of those things is going out and meeting with people, meeting with potential clients, and going to lunch and those types of things. Not even being able to do something as simple as that because all of his nutrition would have to go in through a feeding tube. Being able to communicate, which, like I said, he could barely be able to understand them, and how now he has to convey and talk about financial plans and what this person needs to set up to be able to live based off of a certain
we've handled so many
money.
Cancer-related type disabling claims, and fortunately a lot of claimants get a cancer-free diagnosis, but they're left with residual symptoms. And this is a classic example of a case where the claimant had probably, after chemo, was successfully probably diagnosed as cancer-free, however, had permanent damage as a result of the symptoms of the cancer, which then became disabling. And that's what the majority of the cancer cases are, is it's the subsequent symptoms that develop as a result of the cancer, whether it's physical limitations, whether it's fatigue, multitasking issues, all of those types of issues associated with the inability to commit to any employer. And I'm assuming that's the same thing, obviously, besides the fact that your claim had very strong physical limitations, especially communicating.
Right.
What do you continue to do for the claimant now to make sure this doesn't happen again?
So I'd stated before he was approved for Social Security disability, which I thought was a really important piece of this, because in their denial letter, they essentially had said, Prudential essentially said that just because you're approved for one type of disability doesn't mean you're going to be approved or eligible for another type of disability. This is verbatim out of their denial letter. So it was essentially a brush off, no discussion as to how, what is different, what was missing from the review of the Social Security Administration. But thankfully he continues to receive Social Security disability benefits. That was never interrupted or challenged. And for now, some good period of time, Prudential has him essentially requiring updates, but not as frequently as would otherwise be required, which is monthly or every 6 months. Now he's down to a year, but it's important that because sometimes when you get into these situations or scenarios where the insurance company is not necessarily requiring updates every month, that means that there may be a lack of medical documentation in your case if you're only seeing your doctor once a year.
Right.
So, it's important that we help him stay on top of his doctor's visits, ensuring that his doctors are properly documenting things, that they adequately understand, really the details of his condition, his symptoms, his ongoing problems, if anything develops or changes. Because those are the things that if are not documented properly, the insurance company is going to find again another reason to deny the claim. So those are all the things we're staying on top of.
Right. Well, this was a really sad denial as I listened to it, and I remember when the case came in, I couldn't believe it was denied. But you have a doctor who didn't mean any harm to his patient, but was kind of rushed in the process. The claimant was unrepresented. This never happens when a claimant is represented, in my opinion, because we vet all of the communications that go on, whether it's an attending physician statement, whether it's an insurance company, calling the doctor's office. We say don't have any communications with the doctors. Everything goes through our office. Because the doctors look at things as activities of daily living. When they said, can he eat something? Yeah, he can eat. But, and communicate. Can he talk? Yeah, he can talk, but not to the level to do their job. So there's a different standard between living normal life versus what it takes to actually do a job. And that gets lost in the translation. And Prudential is one of those companies who hires, whether it's an in-house doctor, a nurse, or they hire someone else to have this communication, and they really take advantage of that situation. They don't drill it down, and they never, ever, ever say, are you telling me this person can go to work 8 hours a day, 40 hours a week as a reliable employee? They never ask that question.
No.
Never.
And that was one of the things that we were trying to address through our questionnaire with this doctor, because they have no idea what, they're just kind of speaking with this. They don't even know in some cases. They think they're talking to some, vocational doctor or somebody, occupational doctor at their employer who's trying to, they think they're doing the right thing. Oh, how can I get this person back to to be functional and able to go back to work? Maybe that's what they want. They don't even bother talking to their own patient to understand what it is that they want and what it is that they need.
But the other thing here in this case is that they should have probably examined him. I mean, it's such a strong representation of physical difficulties that just hire a doctor to say, hey, we want to have you examined. They have the right to do it. It would have been a no-brainer, obvious, from the moment this client walked into the room and said anything. And they never even requested to say, hey, can we have a phone call with the claimant to talk to him, to ask him his opinion. Just because they're represented doesn't mean the insurance company can't talk to them. They just call our office and say, we'd like to speak to the claimant. They have a right to interview him. We do it all the time. And so the point is that anyone who's watching this video and is going through this process or has a thing about these companies are terrible, yes, they will seize on any opportunity possible to deny your claim. And you can never let your guard down. You always have to be ready to defend yourself and do everything you can to put the best evidence possible to keep your claim from being denied. And this is a classic example of a person who had a horrific diagnosis, has suffered tremendously, is still suffering, and Prudential says, oh, we see everything you went through, you can go back to work. It's crazy. This client would love to go back to work, and he can't. And so it was really insulting and sad that Prudential did this. Fortunately, you were able to overcome this and win for the claimant, so that was a great victory. If you're someone out there who has a Prudential long-term disability insurance claim, no matter where you live in the country, we're available to assist you. Feel free to reach out to Cesar, myself, any of our long-term disability lawyers. And no matter where you live, we're available to provide you with a free initial phone consultation. We look forward to speaking with you. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process. And when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search, plus we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.